Welcome to a video on laying the foundation for a prior inconsistent statement admitted as substantive evidence. Normally, prior inconsistent statements are admitted for impeachment purposes under Military Rule of Evidence 613. These are not admitted as substantive evidence because they are hearsay. However, if a prior inconsistent statement is either not hearsay or subject to a hearsay exception, then it may also be admitted as substantive evidence. This is most common in two scenarios. First, prior inconsistent statements of the accused are not hearsay under Military Rule of Evidence 801 Delta 2. Second is when the witness made the prior inconsistent statement under oath and subject to cross-examination, such as in an Article 32 hearing. This is not hearsay under Military Rule of Evidence 801 Delta 1. Other hearsay exceptions or exemptions may also apply, allowing other inconsistent statements to be admitted substantively. In the scenario that follows, we focus on the situation where the witness made a prior inconsistent statement under oath and subject to cross-examination. In order to lay the foundation to admit such a prior inconsistent statement, counsel must 1. Lay a proper foundation for an inconsistent statement generally under Military Rule of Evidence 613. 2. Show that the inconsistent statement was made under oath subject to the penalty of perjury. And 3. Show that the inconsistent statement was made at a trial, hearing, proceeding, or deposition. Please listen carefully to the examination.
Ms. Forrest, you stated today that you do not remember kissing my client, Captain Kuo, on the night of the alleged incident.
Yes, I don't remember kissing him.
Do you remember testifying at an Article 32 hearing a few months ago?
Yes.
And you testified under oath?
Yes.
And you swore to tell the truth, the whole truth, and nothing but the truth?
Yes.
And at that Article 32, the prosecutor, Captain Lickbar, got to ask you some questions.
Yes.
And then I got to ask you some questions.
Yes.
And at that Article 32 hearing, you stated that on the night of the alleged incident, you kissed my client, Captain Kuo, for the sole purpose of making your boyfriend jealous.
I said that.
Nothing further, Your Honor.
Government, redirect.
No redirect, Your Honor, but before the witness is excused, the government requests a 39A.
Members, apparently we have something to take up outside of your presence. The members have departed. Government.
Your Honor, immediately following this witness's excusal, the government requests that the panel members receive a limiting instruction that they may not consider the test statements made by this witness at an Article 32 as substantive evidence.
Defense.
Your Honor, the prior inconsistent statement is admissible for the substantive truth of the matter asserted. Because the prior inconsistent statement was given at an Article 32 hearing under oath with the penalty of perjury, and it is not hearsay under MRE 801 Delta 1 Alpha.
Government, your request for a limiting instruction is denied. Recall the members.
In this case, the witness admitted to having made the prior inconsistent statement. With that, the impeachment was complete. However, if a witness does not admit to having made the prior inconsistent statement, the counsel may instead seek to admit extrinsic evidence of the prior inconsistent statement, such as a transcript of the testimony or an audio recording. Before any extrinsic evidence of a prior inconsistent statement can be introduced, the party introducing it has to show it to the witness to give the witness a chance to explain or deny it. This rule is outlined in Military Rule of Evidence 613 Bravo. Thanks for watching.